Today was another wild chapter in the legal saga between Hee-jin and Source Music, and this time, it was over something as modern and explosive as KakaoTalk messages. Yes, we're talking about text messages being dragged into court, scrutinized for their legality, admissibility, and the very real financial consequences that may follow. And as a law student myself, this hearing was not just compelling, it was instructive. Let's break this down into two key areas: what happened today in court, and then my full, in-depth legal commentary on what this means not just for Hee-jin, but for Source Music, the entertainment industry, and honestly, anyone dealing with internal communication in a high-stakes environment. At the Seoul Western District Court, the second hearing of Source Music's 500 million Korean won damages lawsuit against Hee-jin took place. The central issue: whether or not a set of KakaoTalk messages allegedly containing internal conversations can be used as evidence. Hee-jin's legal team argued that these messages were obtained illegally and violated data privacy laws, therefore should be excluded from the proceedings. The court responded cautiously, saying that if the evidence was indeed gathered in violation of confidentiality protections, it might be inadmissible. However, it didn't outright block Source Music from referencing those messages either. Essentially, the court left the door cracked open but not fully ajar. Source Music, on the other hand, claimed that this isn't new evidence. They argued that these were not stolen messages, but obtained with prior consent, and pointed out that South Korea doesn't have a concrete Supreme Court precedent barring such evidence in civil cases. Still, the judge emphasized that if the messages were unlawfully obtained, they would not be allowed. Eventually, the hearing was delayed until June 27th, after the court can fully determine whether these messages will be formally accepted as evidence. And let's not forget, this is all in the context of an already escalating legal battle, where Source Music claims Hee-jin caused reputational and financial harm by alleging the company copied her launch strategy and neglected trainees. She's countered by accusing them of betrayal and misuse of power. Let's start with the big elephant in the room: evidence versus privacy. The court today was wrestling with one of the thorniest dilemmas in modern law: what happens when critical evidence might have been collected in a way that infringes on privacy rights. This is particularly relevant in civil cases, where the lines are blurrier than in criminal law. If you're in the legal field, you know that civil courts can, and often do, allow material that might not fly in a criminal courtroom. That said, Korea's Civil Procedure Act does acknowledge protections for personal confidentiality, and today's judge seemed to echo that sentiment. It wasn't a hardline dismissal, but rather a show-me proof it was illegally obtained, or I'll consider it. That's a smart move, legally cautious, but procedurally fair. What's disturbing, however, is that companies are now walking a tightrope when it comes to monitoring internal communications. If employees feel like their chat logs can be used against them in court without strict boundaries, that could chill communication altogether. On the flip side, if organizations are completely barred from using these messages, especially when obtained through company devices or within work groups, it handcuffs their ability to defend themselves. This ruling, when finalized, will likely become a benchmark in South Korean civil litigation for digital evidence standards. Min's legal team did something clever here. By pushing back on the admissibility of the KakaoTalk messages right before the hearing, they forced the court into a holding pattern. Some would say it's procedural brinkmanship, and they wouldn't be wrong, but it's also a valid litigation tactic. Delay can be a defense, especially when you're trying to buy time, reassess your strategy, or prevent damaging information from being locked into the public record. They're also setting up a potential narrative for a future appeal. If the messages get admitted and hurt their case, they can argue that the court erred by allowing improperly obtained evidence. It's preemptive damage control, and from a legal strategy standpoint, it's textbook. Still, it's a bit telling that they're fighting so hard to keep those messages out. If the content truly supported Min's claims, wouldn't it be to her benefit to let them be admitted? That question alone opens the door to speculation, and that may be just what Source Music wanted. Source Music's approach is the opposite. They're going all in on receipts. Their team wants to show clear, time-stamped, message-based evidence that Min either exaggerated, misrepresented, or outright lied about key events, especially around Les Seraphim's debut and her allegations of sabotage. They're trying to shift the narrative away from Min the visionary betrayed to Min the disgruntled executive rewriting history. And to be fair, if the messages actually show coordination, approval, or mutual understanding, that could dismantle Min's public positioning entirely. But here's the risk. If those messages are ruled inadmissible, then Source loses their strongest weapon, a direct line into what was actually said behind closed doors. It becomes a classic he said, she said. And juries, or judges, are notoriously unpredictable in those circumstances. This is why the June 27th ruling on admissibility could make or break their case. Regardless of who wins this particular suit, this case is now precedent setting. It's a sign to every entertainment company, executive, and employee that your digital footprint, your chat logs, emails, texts can become the core battleground in a legal war. It's also a chilling reminder that company-employee disputes in entertainment are no longer private HR matters. They're full-blown courtroom dramas, often entangled with fan narratives, media headlines, and massive reputational risk. If Min wins and proves those messages were illegally obtained, it strengthens the privacy shield for future whistleblowers or dissenters inside companies. If Source wins and gets those messages admitted, it tells companies, document everything. Because your own records may become your first and last line of defense. Min alleged that Source Music neglected the NewJeans trainees who were previously under their care and accused the company of copying her launch strategy when debuting Les Seraphim ahead of NewJeans. In response, Source Music issued a firm denial, stating, Hee-jin's claims that Source Music copied her launch strategy are false. We never copied any plans or acknowledged her complaints at the time. They further added, in May 2020, Chairman Bang Si-hyuk responded to Min's proposed launch strategy by suggesting she develop it through a new team within her own future label, not Source Music's team. Despite knowing this, she continues to distort the facts as if the strategy was intended for the in-team. Source Music concluded, Hee-jin continues to spread false information about Source Music. In addition to the existing damages lawsuit, we plan to take strong legal action regarding this matter as well. We are also prepared to disclose internal data at any time to uncover the full truth. And so, that's it for today's case. Let me know what you'll think in the comments below.